Let's move to the next panel discussion. The topic of the discussion is practical approaches to mitigate the risk of insolvency and bankruptcy. This session will touch upon points like group and cross-border insolvency regime in the wake of global financial recession, the future of IBC, strategies to tackle clogging tribunals, authoritative IRPs and taxation issues, strategies to reduce the risk of insolvency, etc. I would like to invite Veena Siva Ramakrishnan, partner, NPG Banking and Finance, Shardul Amarchand, Mangaldas and Company, to moderate this discussion. She has over 16 years of experience and has previously worked at Juris Corp for over a decade and at ICICI Bank mainly for its offshore operations. She has significant experience in banking and finance, financial services regulatory, derivatives, insolvency, bankruptcy, and restructuring. Over to you, Veena.
Good afternoon, everyone. It is my privilege today to introduce a very esteemed panel here. The topic that we would be discussing is the practical approaches to mitigate the risk of insolvency and bankruptcy. I think everybody in the audience, as well as my panelists here, would have been in conferences on this topic of IBC, at least in 3-digit numbers. What we thought we will do today is we will do something slightly different. We will move beyond the law. We will look at what the practical impact of the code has been. As you will note, the panel is fairly balanced. So you will hear both sides from the regulator's perspective, from the investor's perspective, as well as from the industry's perspective. And given that all stakeholders play a very important role in how this actually pans out, it would be interesting to see the unspoken and the controversial issues pan out over the course of the next 1 hour. Let me introduce the panel. The first speaker I have today is Mr. Chandiok. Mr. Chandiok is a practicing senior advocate. He is currently the president-elect of the most prestigious Bar Association of India. He is the president of Insol India and Madhyam International Council for Conflict Resolution. He has been a former Additional Solicitor General of India. He was also the principal counsel to the European Union Commission for 3 years. It is interesting that he is the only Indian lawyer who has held that position for this long. He was the president of the Delhi High Court Bar Association for 6 terms. I think the audience doesn't need much introduction about him. He has been conferred various awards, including the Outstanding Jurist. He has been the leader in the profession and leader in the bar award. The fact that he holds this position itself is introduction enough for what he has done in this field. Let me move to my next speaker. My next speaker is Mr. Badrinath. Mr. Badrinath is a senior vice president and head legal for the SR Group. He has over 28 years of experience in mergers and acquisition, contract management, strategy, etc. He has been involved mainly in legal and financial due diligence, closing of transactions, joint venture formation, and prior to SR, he was a legal head of L&T and has had the experience of working with various multinationals such as HCC, United Phosphorus, RIL, Asian Paints, etc. My next speaker is Mr. Kanhaiya Thakkar. Mr. Thakkar is the general counsel for Ambuja Cements at present. It's a large group company of Lafarge. He leads a long legal and compliance team for Ambuja Cements. Mr. Thakkar is both qualified lawyer and a company secretary and has previously worked as a general counsel with Asian Paints Aditya Birla Group. And he has also worked internationally in US and Germany. He has handled a range of mega merger projects, and I'm sure that most of them would have seen insolvency issues, and therefore his experience in that space would be very relevant from evaluating legal and compliance processes that we talk about today. My last speaker is Mr. Ravi Chhatra. Mr. Ravi Chhatra is the CEO of JC Flowers and ARC. He is also the CIO of JC Flowers India Opportunities Fund, which primarily invests in distress resolution and turnaround opportunities in India. Everyone here would know that JC Flowers India Opportunities Fund is a JV between 8 Capital, which was founded by Mr. Ravi himself in 2005. It focuses on investing in distressed and special situation opportunities in India. Prior to launching 8 Capital, he was an investment analyst and a portfolio manager in New York and London, where he has worked with global financial institutions like JP Morgan, Deutsche Bank, Goldman Sachs, and TCG Group. I will move to the panel, and I thought we can start with the questions itself. Let me start with you, Mr. Singh. The IBC has been in place for 4 years now, and we hear a lot of quotes like poor company, rich promoter, take money away from those who brought it to this stage. But these were in the beginning, and these seem to have reduced to some extent. Also, what has helped with COVID in some way from an IBC perspective is that the IBC itself got suspended. It probably gave both borrowers and lenders the time to rethink of alternatives on how can they deal with a payment default. What do you think has been the biggest opportunity in the space outside of IBC?
Thank you, Veena. I think the biggest opportunity IBC's suspension made was that it gave an opportunity to the corporate debtor, the promoters, the legal minds, and above all, I thought a mediation movement came into place where we brought in a concept of settlement, rewriting of our contracts, looking at force majeure in a different way, and looking at restructuring outside the IBC. Therefore, the greatest opportunity was a breathing time to the corporate debtor to look at people like Ravi and ask him to fund the stressed assets, to look at Mr. Badrinath to help us out to see how we can make any acquisition or merger, and to see how we can have the compliances through, which were probably in default with some time, and maybe with the help of Mr. Thakkar. So the greatest opportunity I think the COVID gave us was we have evolved a system, which in fact there was no statutory provision in terms of IBC. We took our principles from the Companies Act and we started looking at how do we resolve. In fact, you will find the first 12 cases that came under IBC under the direction of the Reserve Bank of India. Many things were said, many criticisms have been made, even with respect to RPs, even with respect to courts, that they have taken so much of time. But the law that has been laid down in those 12 cases are actually laying down the foundation of IBC permanently. You will not find today those issues being raised. They are already set at rest. Limitation, for example, to give you an example, people thought that limitation would start with something else would happen to it or something not. But everything took its time. So today, I think the opportunity that came to our way was to look at all this, and we have now resolved, and I can speak for myself that I have at least been involved in 5 rewriting of the transactions between the parties, their agreements. We have been able to resolve out of 9 mediation matters came to our fold. We have resolved 6 out of them. 2 are still in process, 1 has failed. Now, this is a new opportunity. Now, restructuring under the Reserve Bank of India's circular, for example, of June, that made impossible for the financial creditors to look upon everything else and go back to the corporate debtor and resolve the issue. There has been an issue with respect to pari passu charge, with some of the pari passu charge holders not coming to the fold and not agreeing to the restructuring process. For example, that has happened in Reliance itself. But that I don't think in case of isolation should anyway tell us that we did not get an opportunity to re-examine ourselves, to re-look at our agreements, wherever we thought we could give time or we can lay down new principles, redefine force majeure, look at stressed assets to see how we can make them once again applicable with the promoters in place. You see, the greatest disadvantage or advantage people call it to IBC is that the moment Section 14 order gets passed and RP is appointed or IRP is appointed, the management goes out of picture. But with the suspension of Section 7, 9, and 10 of the IBC, that jurisdiction was taken away. And therefore, it was an opportunity for the corporate debtor to come back, to look at its options, go back to some creditors, resolve the issues, one-time settlements. And that opportunity, I think, has been well availed in the last few months that we have seen COVID.
Thank you, Mr. Chandyo. But do you think, and this is a question more for Mr. Badrinath and Mr. Kanaya, do you think that there are other opportunities which are actually viable outside of IBC, which are being used adequately today, especially with the suspension of IBC? There are other opportunities which have opened up because there are COVID relief circular, etc. So from a borrower's perspective, Do you think there are enough opportunities which can be availed and which are actually meaningful, where the lenders are actually giving credence to these mechanisms?
Good afternoon, everybody, and thank you, Veena. I think you put the right question. The issue here is that I think the IBC has given a wonderful opportunity to everybody, as Mr. Amarjit was saying about a kind of a rethink in this particular COVID times. First of all, it's a very robust legislation. There is no doubt about it. Both for the financial, operational creators and for the promoters of the companies, whomsoever it may be, it's a good code that has come into the domain. My only observation is that I am representing the kind of a corporate debtors side I would be representing. So obviously I would be speaking about the kind of an improvements that are required in the kind of the system. Yes, it has done a world of good, but at the same time, there are certain kind of a loopholes which have not been addressed in the IBC. The Indian context is altogether a different context. Initially, it started with a family-driven business, followed by a kind of a corporate structuring, and finally it evolved into something big on par with the global companies. There is no doubt about it. But when you tackle the IBC, we feel that from a corporate debtor side, it's been completely lopsided in favor of the financial investors, because it's serving the good of the financial mechanism rather than looking at the kind of ethos with which we have been brought up in the system. As Amarjit was rightly saying about it, that we are looking at an option to see that we do have a face saving and we do really honor the commitments, but nonetheless, there are certain points which we need to address as such. The first and foremost I need to say about the IBC is that we need to differentiate between the financially distressed asset and economically distressed assets. I think that classification has not come in the system. An economically distressed system is something which can be up for liquidation. That's a different call. But when it comes to a kind of a financially distressed system, I think there are various mechanisms which we need to do, and accordingly we need to think about it. And that's where I think the most of the corporate debtors are feeling the pinch that we are walking into a kind of a legislation without adequate safeguards for ourselves to kind of either extricate or negotiate or arrive at a settlement. I think the biggest pain which the promoters or the kind of corporate debtors have it is that it is slightly lopsided. So let the financially distressed assets be classified in a different category, and then accordingly either you have a restructuring plan in place amongst the people who qualify for the restructuring, or that of you can have the kind of other settlements which can be done as provided into that. But unfortunately, this is one thing that is which is not happening. The second and most important thing is that when you put up the information memorandum, most of the times the corporate debtor is walking into the hands of its own competitors, so that they are very well aware about it. So the kind of the limited rights and the safeguards one need to have are not being adequately provided under the IBC. So today, if a corporate debtor walks into the IBC, he has to walk into with a kind of a head hanged in shame. It's not that he was also running a big corporate till that point of time, and he need to have his own rights protected. I think that's something which need to be protected in the system. And the last point I would like to say in the first round is that the financial creditors, the ones who really run the finances, I'm not saying that they are doing their part of the duty, but they don't have the kind of emotional feel or a kind of a business connect with which a corporate has been drawn into this kind of a situation, and how best to resolve the situation and try to make them up and working once again altogether. No, I think the financial creditors are really taking the kind of things on that stride and seeing that the kind of a stranglehold is exercised at every level of the IBC. I think these are the three biggest concerns which I have, if I have to sum up in a kind of a nutshell.
Sure. Thanks, Mr. Badrinath. But just to take it forward from what you mentioned, do you think that given that IBC has now been suspended, and as Mr. Chandiok was also saying that there are avenues and he has practically seen situations where things are getting resolved outside of IBC, just from a broad picture perspective, do you think that the corporates are seeing this as an opportunity where they can come up with a meaningful restructuring plan by the end of the year, which is required under the RBI circular? Is that something that the corporates are at least looking at it as a welcome change, or is it something which there is a general belief that it's not sufficient and there is something more which is required to bridge the gap?
I think it's a wonderful question, and you have the answer built into itself. But let me tell you the corporate debtor perspective as such, because I represent the industry. Some of the companies which are under our chain are also facing the kind of a heat, but nonetheless, it's a great opportunity. The COVID is an opportunity notwithstanding the business losses, notwithstanding the IBC mechanism, we ought to have intervened into. But still, we are looking at every piece of the puzzle to be really been kept in place, and see that we want to extricate ourselves from the difficult situation where we are put in. Yes, these are the business difficulties. Every industry would have it, and every promoter would have it. But point is that this is a great opportunity, as Mr. Amarjit was saying about it, that we are looking at resolving many issues. And to my knowledge, I have been actively engaged in at least 10 of the deals at the moment, in terms of how best not to get into kind of an IBC. That itself speaks volumes about it. That's number one. Number two, this is a little long drawn process than that of a December deadline. I think already people are actively engaged in this mechanism of a negotiated settlement and coming to some kind of a grips not to get attracted into IBC. Given that kind of a mindset, and which the government is equally aware about how the things are panning out, or tomorrow it can be demonstrated by the financial creditors, yes, there is a thing which is happening, because ultimately the financial creditors are the ones who drive this into kind of IBC mechanism. So, or operational creditors for that matter. It is a known fact that whether a negotiated settlement is happening or not happening. So accordingly, I think there has to be another 1 year time limit, or at best a minimum of 6 months to be given for us to reach to the end of the tunnel as such. But yes, I would vouch that there is a lot of positivity happening because of the kind of a suspension, and we need a little more time to really bring it to a kind of a conclusive and a kind of a displayable kind of a scenario.
Mr. Kanaya, has your experience also been similar, or do you feel that there has to be a change, or there has to be something different too?
Well, as Badri has rightly mentioned, that suspension is one of the opportunity for the corporate, but specifically for economically stressed assets, unlike financial assets, some sort of restructuring for the debt or some economical stress assets need to work out. And not only suspension, but during this COVID period, whatever the erosion of the loss for the entities has to be removed from the total quantum. Then it is a real help, or these things. Otherwise, suspension is nothing but delaying your problem. In a pandemic time, those entities which otherwise viable has going to the stress because of this COVID situations. So this angle has to look into properly. Number one, after completion of suspension, this excessive petition will be filed, and that excessive IBC petition after completion of suspension will create another financial instability in the system. So suspension is not enough. According to me, I think we have to see that as per the formula when you're going into IBC or situation, quantum of the loss, erosion of the loss, or payment or the liability or obligation during that suspension period has to be recalculated. Then only real benefit will be given to the business which is otherwise viable. Number one. Number two, RBI is financial related areas. But I think for the corporate restructuring has to different looked into, because today presently the entire IBC revolving on the financial assets, but we need to do something about economically viable or unviable assets as well. So the two things are different, because that's real sense. IBC does not want to do force liquidation. IBC want recovery of assets. So that's all about suspensions and restructuring the debts and stress assets.
Thank you, Mr. Kanya. Mr. Ravi, I'll move to you. I think everybody says that lawyers make money in good times and bad times. And in COVID times, people say that stressed assets, special situations fund and ARCs are the ones who are actually making money. There is one perspective to it, which is that the times are uncertain and people don't want to take risks like the way they used to. But given your experience and given the entity that you are a part of, I think taking risks is almost with your day-to-day life, right? So from that perspective, do you think that irrespective of COVID, just generally IBC and the opportunities that have arisen, how do you think that has panned out?
Thank you, Veena, and good afternoon, everybody. So, this IBC situation in NPLs in India reminds me of a sheikh from Mirza Ghalib, कि बर्तनों की आवाज तो आ रही है पर खाना नहीं आ रहा. So, and I don't say that in so much in jest, but in practicality, that IBC, as everybody has recognized, has been an amazing piece of legislation that is obviously looking through all the dirty dozen, etc., jurisprudence is getting created, and that's a great thing. Even in the US, Chapter 11 took a decade for the jurisprudence to get created, and therefore we expect the same thing will happen in India as well. At 8 Capital and JCF ARC, we have bid on 6 different companies in IBC, and some of them are still in process, so we have a ringside view. However, on some of the comments that people have been talking about of the suspension during COVID and what that means, so when we look at high yield or stressed in India, it has always been a difference between the haves and the have-nots. So what that means is that when a company has a good management team with a bad balance sheet and a business model that can be restructured and turned around, there is so much liquidity in the world that it will find that company. In sometimes we also compete with growth equity because they would like to turn these companies around themselves, or they may have investments in those companies and they're topping up, even during the times of COVID, and we will be seeing that. What we found, pre-IBC is that the most difficult thing that we would be, negotiating is with the promoter group on what they think is the perception of the value of the company and what we think makes sense for us to invest in to get our returns for our investors. Post IBC, obviously, the promoter has been out, and therefore you're dealing with the resolution professionals and the lenders. And there is the promoter still lurking around somewhere in the background. So all of these 3 are large impediments because there is no cohesive lender, even though we have Shashakt, etc., and ICA, it's not really effective. And therefore, how to get into these companies is very difficult. And then you have the resolution professionals. Although most of them are amazingly professional, there are certain ones that have given the sector a bad name. And all of these things discourage investors to come in and capital to flow into India in these sectors. And obviously, Section 29A was set up for a certain purpose, which I believe the time has passed. And we need to get Section 29A repealed so we can work with the existing management team itself. Because as investors, we are not running companies. We want to invest in companies and put money behind good management teams. And that is important for us. So I'll leave it at that there is enough money for good companies that needs to be restructured and can be turned around. But when it comes to really distressed companies, there is heavy lifting involved and they have to be put back together. There is just too many impediments for a lot of people to come in with capital at the moment.
Thanks, Mr. Ravi. You touched on a very important aspect of how 29A has probably outlived its utility. I want to come back to you, Mr. Badrinath. From your experience, and especially when people have been talking about commercial wisdom and how it is the promoters who know, you mentioned about the emotional connect that people have with the company itself also. From that perspective, what is your sense? How does the market view 29A, especially when there has also been an introduction of other amendments in the code, where a company can be taken out of IBC after a specified period of time? What has been your perspective on that?
I think that has to be there, the way in which it is provided for. I think because the things can change the way in which one can change. But I'm happy to hear about the Ravi's mindset when he stated that we wanted to be behind the companies in its running, and we'll only provide the capital, but as far as the management professional is concerned, we'd like to run the way that it is running as such. I think that's a very positive note. I think I can see the sea change which is happening from the investor's point of view also. But this 29A, it is serving its own purpose, and it has to be there for its own sweet thing. Because every piece of legislation need to have its own kind of a settlement period. Be it Arbitration Act, be it any other act which has been introduced, there is a kind of a time which will see through certain tests and certain litigations as such. Here also the same thing we are passing through the phase as such. Definitely it is going to help us in terms of settlement of many disputes going forward in these things. It's a very well drafted legislation, and this section definitely has to stay for some more time to come.
Thank you. I want to just shift gears a little, because there has been a lot of noise in the recent past about the role that ARCs play in the entire resolution plays, and whether or not they can actually be a bidder, etc. Mr. Chandyok, from a legal perspective, how do you view this? And there has been so much noise, there's been so much press about it. And on the other hand, the law is actually silent. But what is your perspective? How do you think this will actually pan out? And what do you think would be the actual commercial outcome of these issues that people have been speaking about?
There's a change of time, and the change of time can bring change in law. There's no dispute on that part. Please look at it when we brought this legislation in 2016. If you see the report of this and Mr. Vishwanathan and thereafter the legislation, people had apprehension that there is no profession called resolution professionals. How will we come out of it? And I think Mr. Ravi has rightly pointed out, there could be some black sheep in every professional. There is a black sheep. But by and large, the resolution professionals have shown to us a way forward and given us a good profession today. And we find excellent work being done. And I'm proud to tell you some of the matters where resolution professionals have actually done wonders for the corporate debtor and done better than what the management was doing. So it's not that it is not done worth it is. There is always a criticism. There's a change of time. As Mr. Ravi said, that we like to back up the old management. You see, when we brought this legislation, unlike any part of the world where we do not bring a RP straight into the picture, we always let the corporate debtor with its promoters continue for some time till we bring the resolution aspect, whether we take it United States, whether we take UK, whether we take European Union. But we had different circumstances altogether. Our experience in the winding up showed we were not able to do anything. In experience with SICA showed we failed. Therefore, the legislature was looking at it to find out. The NPA was growing manifold. You see, we must take note of the fact that from 1998, after we opened up our economy, lending went very well. People were given the finances so that we could establish industry. We can go have joint ventures. We can have all kinds of things to do. But in many cases, we found people were intentionally not able to manage it, or they didn't have the capacity to manage it, or they did not bring professionals to manage the company. Therefore, that's where though I agree with Mr. Badrinath that many times it's the family for decades or probably generations that a particular business has come from in our country. But time had come when we had to compete the world. And look at what we have done. By IBC, notwithstanding that we don't have a cross-border situation, our court took note of the appellate tribunal, took note of Jet Airways, for example. And had we not brought the administrator within the fold of the committee of creditors, we would have never resolved that issue. We resolved it. Therefore, there can be criticism of his situation. Today, it may be relevant to say whether 29A has lived its life or not. But 29A brought in the factor that you found many people as resolution applicants coming to bid for it. The times have changed. I am not disputing that part. And therefore, I thought this COVID time was a time for corporate debtor and its promoters to utilize it to resolve their disputes. And I think Mr. Badrinath rightly said to that extent that yes, they are resolving it and they need more time. Now, if I am in a resolution process is already in place and probably parties are negotiating for some time or some document has to be executed or some other ends have to be put, loose ends to be made up, that's a different question. Nobody's going to take you to IBC. But the fact of the matter, and I think the issue that is today erupting very fast is that if a corporate debtor through its committee of creditors have sat down and agreed to a resolution plan to say, I will against 100 rupees or 1,000 rupees, I will only take 100 bucks. Can you still burden that corporate debtor's promoter for the balance amount? Is a question, I agree, is debatable because you are party to that resolution plan. You have yourself said, I'm ready to accept a cut to the extent of 40% or 30% or 80%, whatever the case may be. Then how do you fall back on a guarantor? Though I agree, the liability is coextensive, liability is everything. But I have agreed to cut them down by my own decision. The financial creditor was the decision maker in that. Should that be a question which should erupt out in the coming jurisprudence under the bankruptcy law, especially when we have brought guarantors into the fold of bankruptcy and we have brought that chapter to operation. These will be questions that we might have to ask. These will be the question. Look, we had once said there can be only one resolution plan. We changed that situation. Now there can be more than one resolution plans. So, and we have now we have ironed out many difficulties that we found, right from Swiss ribbon, right up to BK education and everything on limitation. Therefore, I think time has come where we will do like it. And I have no difficulty in accepting that this is one legislation where every stakeholder, whether it is Ravi, who's an investor, whether it's Mr. Badrinath, who is in industry, whether it's Mr. Thakkar, who is also from the industry, or lawyers. In fact, you made a remark that lawyers always make money. And I wanted to tell you, in fact, we did a survey in 2012 by youngsters who came just from out of the IT situation. And in the Supreme Court, we were able to establish that 62%, we had given our own yardsticks, who will be below poverty line, who will not be, if he's bachelor, he's married, he has 2 children, everything else, etc. And you'll be surprised, we found 61.39 to be exact, but below that poverty lines that we fixed up. So don't go by the bar that you see A, B, and C. No, that's not the bar. Bar is that little lawyer who is working in Mustafil, a bar who is working in the district court. There are many people during this COVID that I know of personally who have not been able to carry their kitchens together. They have not been able to pay their fee in the schools. So yes, lawyer do. I mean, I agree. When a case is lost, I still go and appeal and take my fee. That's okay. But by and large, do not go by the 2% or maybe even less than 2% people in the entire country which may be doing that. But by and large, the profession has faced challenges. It has come out of those challenges. And I think the way the law has been assisted, the lawyers have assisted the court in coming out of principles in insolvency itself under the IBC itself should be a sense of pride for this country. And in 2018, we won the World Award to be the best jurisdiction in IBC. And therefore, that was only possible only if the stakeholders like industry, investors, lawyers, judges, everybody collaborated. So collaboration, I think, is the need of the hour. And that I take it back to the constitutional provision. That's why the makers made it secular, that without caste, color, creed, or religion, you are one India. And therefore, we all, whether we are investors, we are industry, we are lawyers, we are judges, we must collaborate to ensure how we bring economic reforms back and bring our economy back into the frame.
I would like to supplement the thoughts of Amarjit ji. I think he has hit on the nail. But if you permit me, I would like to state only a couple of things.
Oh, sure.
Okay. Number one is that I think he said it very right, that the lawyers and the resolution professionals are the ones which are assisting a great deal in terms of the process that is going on at the moment. There's no doubt about it. On the fee, there was some comment which has happened, but that's a different issue. But today in the COVID times, there are many firms which are reducing their fee as well, and they're giving a steep discount. This is for the knowledge of the public, so one can really negotiate the fee as such. That's the second thing. But the real part I would like to state is that if the IBC mechanism has to be robust, and there has to be a mixed blend between the ethos which I've been talking about it, and getting into the internationalism where we need to compete with the world in terms of the IBC types of processes, I think a little leeway need to be given for a point of time. Like in the case of the suspension due to the COVID times, what we need to have is that we need to have a kind of a representation by the corporate debtor during the process when the IBC proceedings are on, which today is not being facilitated the way in which it ought to have been facilitated. I think that's where I think the things will improve. The objectives will be set in tone, and that's where the representative nature of the corporate debtor will showcase the kind of the sincerity and the commitment he has for bringing the kind of an economic reforms to put it back on the rail. That's one point. The second point is the withdrawal mechanism. The withdrawal mechanism is another one which is not facilitated in the IBC process once the process starts. I think these are the twin objectives which we need to build into the systems. I'm sure there will be a number of amendments which will be coming to IBC. There's no doubt about it. But there is a thought process also in the ministry, as I was given to understand as such. But these are the ones which will really facilitate what Mr. Amarjit ji is talking about it in terms of bringing back the economic reforms on the rail and showcase India in the best of the world for the investor fraternity to come in and for all the AMCs to the others to put in money to bring the industry back. This is my supplement.
Just staying with the thought of how ARCs as a financial institution have played a role in the entire resolution. Last year, we saw a very significant change in the IBC, which was to bring in systemically important NBFCs within the fold of IBC itself. It is popularly believed that there has been only one case which has been referred under that, but the stress in the banking and financial system has been existing for some time now. Mr. Thakkar, how do you view this? Do you really think that this has been a welcome change, or this has its own issues? Just from the perspective of when you look at a regulated entity.
Well, Veena, we discussed and heard a lot about IBC, and my view on the subject is like a glass of water is half empty or half full, the way you see the things. Now, it's like, as a student, I have studied a lot. I have given an exam as well. But ultimately, I'll be judged by how much marks or percentage I get after exam. Now, to give the view about IBC success or IBC is in a way of success or it's failed, I would like to throw some numbers here. And according to India, till date, around 2,500 accounts has been referred to IBC proceedings, NCLT. Out of that, only 155 cases, a recovery of the assets has happened, and more than 550 cases has been forced to go to liquidation. Now look at this number. The whole objective of the IBC is not for the liquidation, unlike this BIFR, earlier BIFR and SICA, but to restructure and recover the assets, stress assets. So this number says that, are we near to our objective, desired objective of the IBC? I think the answer is no. Now, second thing, look at this again, recovery of the assets number. Only 43% assets has been recovered. While, and in this 43% recovered assets number, if you remove the 7 major accounts out of 12 big assets accounts, only 30% percentage of the recovered assets has been possible. Recovery is possible. And what was the number earlier before the IBC? Before IBC, during the BIFR and SICA, 27% recovery. So if you see the number, Veena, before IBC 27% recovery, after IBC 30%. If you remove that 7 major numbers, even if you say 43%. So number says many things. Where are we on the IBC part? So point which I'm trying to say here is that IBC, no doubt, is a welcome movement, is a good legislature. But as I heard Badri and Amarjit Singh and Gajendra was talking about resolution profession. But in India, resolution profession, no doubt, doing good job now. But resolution profession as of today is sticking to only lawyers and chartered accountants and company secretaries to more extent. I think it's a high time that these resolution professions should be institutionalized rather than individual skill. We need to mix up with these lawyers, legals, and chartered accounting skills with the entrepreneur skills, non-graduate skills, because ultimately successful businessman is not always a lawyer or chartered accountants, but they're also a non-graduate as well, and we see that. So entrepreneur skill, competency of the handling the business, that skill need to mix up with this skill which we are talking about. And then we'll see this restructuring of the entire debt restructuring and IBC will lead to the high level of success to us. So this is my take about success, and a lot to do success, achieve the success about the IBC. And coming back to a question about this recent notifications in November 2019 about financial service providers and NBFC also has to go to the IBC proceedings through NCLT. According to my personal view, this is not at all a good moment, according to me, because anyhow the NCLT is backlogged with many IBC proceedings and processes slow. Out of 100 cases, 60% cases are pending yet, and 40% only covered. They are already backed up. Judiciary and tribunals are already backlogged and burdened with this NBFC, non-financial sectors, and now we are putting additional burden on that. So I think the way forward, this will impact further in slowing down the recoveries under the IBC proceedings. So instead of that, I personally feel that we should have a separate financial authorities for the NBFC and financial service providers, rather than clubbing with the generalizing with the NCLT to look into with other corporate structures. I think this is my view on the subject.
Veena, here too, I would like to
Thanks,
supplement,
Mr.
if you permit me again. I'll agree with most of the points Kanai has stated. They are very positive points which he said about it. That is in terms of reforming and improving upon the IBC process, the way in which it is going about. But the one difference which I would like to pinpoint here is that compared to the previous legislations, which have not brought in any kind of an economic discipline or organizational discipline, IBC has brought in a substantive discipline in the mindsets of all the promoters, all the entrepreneurs, and everybody who is there in that kind of doing a business in India. I think that's a fundamental difference. IBC is a legislation which has drilled its sense into the minds of every entrepreneur, and they are aware about the fact that unlike the previous legislations, where it's a question of a plug and play and wait for some time kind of an attitude, IBC is a very serious business. Everybody has recognized. That's a fundamental change which it has brought in. Two, unlike the previous legislations which have been either supported or not supported by a set of institutions running up to the Supreme Court, IBC is the one legislation which has been steadfastly supported by Supreme Court, giving a bit of a tweaking here and there, but the legislation has been held in very high esteem. I think these are the things, as Mr. Amarjit was saying about it, which are very much required for the economic upliftment, unity of thought, doing a business the way in which it has to be done, and respecting each other's rights and obligations. Today, I can tell you from my own sense, when we talk to the promoters are very much concerned about the IBC, and promoters would like to fulfill all the requirements that are expected of under the IBC process. Such, I think this I have not seen in my experience in the past. The promoters used to behave differently, but today that has brought in a lot of what you call this, a systematic kind of a discipline. I'm sure Amarjit or Kanaya can add to my thoughts, but nonetheless, this brought in the kind of a discipline. The numbers may be the same, the percentages of 27% versus 30%, that could be a different thing. I'm not debating on that. But in terms of the discipline or the mindset, it has brought in a sea change. Today it could be 30%, tomorrow it's going to be 60%. That is the hope with which we are living, and to take it forward as such.
Mr. Thakkar,
No, I just wanted to add on few comments to what Badri has said. And therefore, in my conversation, I said that how you're looking a glass of water, it's a half empty or half a full. So when Badri says that, yes, I fully agree with Badri that IBC is a good, successful legislation to the extent of bringing the discipline and deterrent to the promoters who are willful defaulters. But having said that, once we are matured enough into IBC proceedings and structuring, deterrent and discipline will be the past, but the way forward, we have to look at that, how successful IBC will do on restructuring, rehabilitations, and, giving the breath to the dying body. So deterrent is fine, discipline is fine, but then once you achieve that desired objective, which I agree with the Badri, the next step is to how we should match with other countries' international IBC structure, the way they are working, and match to that objective. That's my point.
Mr. Chandyok,
Yes.
I was just wanting to.
I just wanted to add to what Mr. Thakkar was saying to make it institutionalized, and I was bringing to his kind attention that we started arbitration in 1940 before independence, where we always used to have either the family member or some elderly person doing arbitration. Then we brought a system of ad hoc arbitration, which still continues. Till we brought maturity into the system, and we have now started looking at institutions as arbitrations, like FICCI, LCIA, ICC, Singapore Arbitration Center. Now, you must give, it's just 4 years gone down the line. I think you are looking at, and I, with all humility at my command, we do not accept that this legislation is meant for recovery, whether it is 43% or it is 30% or it was 27%. This was meant for maximization of assets of the corporate debtor and to make it available to a resolution applicant who could run the industry for the betterment of employment of people who are employed there. Therefore, the purpose, and I am looking for a day, as a matter of fact, I do not know when it will come, when a resolution plan by Mr. Badri in comparison to a resolution plan by Mr. Thakkar, maybe Mr. Badri may give me lesser amount back, maybe 27%. But if Mr. Badri's acumen to turn around a company is far superior than Mr. Thakkar, I think the corporate committee of creditors will opt for Mr. Badri and not opt for Mr. Thakkar. This today's concept that I must have cash back with me from the financial creditor is not correct. That's not the aim of the statute. And to add to what Mr. Ravi had earlier said, you see, when we started this new system of restructuring, we never used to get interim finance. Today, the situation has changed. Investors are coming for interim finance today because they got the priority right. And I wanted to tell Mr. Thakkar that experience shows to me, speaking for my own self, that people whose orders were passed for liquidation, then we brought a concept in law by which we said a resolution applicant or a liquidator would also try to settle as an ongoing process, company only, even after the order of liquidation. And we succeeded, at least to my knowledge, about 17 companies in that case. Now, thereafter, we have now gone in liquidation process where we are still not breaking the institution. We are still wanting to give it out as a going concern. Therefore, I understand where you're coming from with respect to that. Our experience is quite bad in this country. But I think we need to self-discipline ourselves. Look at your COVID. The moment lockdown has broken out, we are not even wearing our masks, not even maintaining distances. So I think what Mr. Badri has said, this system has brought, IBC has brought discipline into the entrepreneur. Now, entrepreneur will become part of the resolution process. I don't think the day is very far. I'm looking at it in the next few months or maybe next few years. You will find this institution will be created. Then institution will become resolution professionals in days to come. The law will take its change. Please take it from me. It will develop. We need to become mature. Therefore, we said, please look at it. We said every lawyer or every chartered accountant who's for 15 years or 10 years of practice can become resolution professional. We then change the system. We brought a new resolution professionals directions. We brought in our examination. We have created an institution at Manesar now where we are teaching youngsters to become resolution professionals. So the development is taking place. And this is what Ravi is going to look at. How I am developing this system where he gets his security that he can invest, take something back, and maybe when a time requires, he can exit. In fact, an investor in this country was not unhappy with us. He was only unhappy that when he wanted to exit, he could not exit because there was nothing to exit on. Today, that's the possibility that this institution has brought in, that IBC has brought in. Therefore, I think my view would be, I must look at positivity. No man, no institution, no enactment can be perfect to my mind. A human being is not perfect. If he was perfect, then he would be God. Therefore, no enact can be perfect. However, the way IBC has changed, look at the regulations brought time and again. Look at the statute being amended 4 times by the statutory provision. Look at the suspension brought in times of COVID, are all signs that everybody is awake. Nobody is sleeping today with respect to this legislation. And I'm sure time will come when your dream that a resolution professional would have entrepreneurs in it, I'm sure it will come true one day. And I want to share one more thought on it. When we started mediation in 2002 after the amendment of law, in fact, we lawyers opposed that thing and said probably our practice will be ruined if you bring mediation. And today, to tell you, I have 200 people on my list who wants to go for training. And I have no time to give them the training. That's the difficulty today. Therefore, institutions are built. And if all stakeholders are ready to contribute as they have done with respect to IBC, I find no. And one more answer which you have said with respect to pendency of cases. I do not know, but my own personal view is that in this country, rule of law still prevails, and that's why my courts are burdened with cases. If there was no rule of law, then nobody would like to go to court. They still have their strength in court, notwithstanding a lot of criticism of Supreme Court of Article 32, this, that, 370, etc. Still, I think the courts have done wonders. But I would say if there is one uniform situation that we have, a uniform, please don't create one commission or one tribunal after other. Enough tribunals are in the place. In fact, I would say you should make an IBC tribunal distinct from Companies Act. I can still get into that. And today, in fact, today the judgment has come from the Supreme Court. They have upheld the rules of 2020, where the appointments to the tribunals were withheld only because the matter was pending in the Supreme Court. This morning, the judgment has been delivered. I'm sure all vacancies in the National Company Law Tribunal or adjudicating authority shall be filled up by the government. These recommendations already made by the Supreme Court are pending with them. And you will find more judges. Yes, I am one with you on that, that professionals should, now it's time for lawyers and chartered accountants, company secretaries, and people like you to come forward and say, I will lend my hand to sacrifice myself, not have my 20 lakhs per month salary, and with all that posh, I'll probably go to the bench and probably do this job. That's the time. And I think if you ask me my time of practice when I came to the bar in 71, 72, 73, if I would finish a case, Mr. Badrinath would finish a case, the Chief Justice would say, Mr. Badrinath, it's time for you to sacrifice now. You have made enough money for yourself. Do something for the society. Do something for the mankind. Do something for resolution of the disputes. And I think within 4 weeks, you would find the man on the bench. That's the system I need to bring back. We need to bring confidence in ourselves. There is no talent in the world which matches India. And please look at that talent. The talent is not being utilized. We need to utilize that talent for the right perspective. That's my view.
Very well said, sir. Very well said.
Thank you, Mr. Chandyuk. I think you raised a very important point of resolution versus recovery, and in the entire implementation and the media attention that IBC generally gets. I think people are forgetting that this is a legislation which was meant to maximize the value and therefore be towards resolution, and it is not a tool for it's not a recovery mechanism. So it's not fair to compare it with a SARFACI, or it's not fair to compare it with any other legislation which was primarily meant to just recover the debts by the creditors. I think just from the perspective of how this is going to pan out, if I were to move on to my final question to all of you, assuming that all of us were in 2025, sitting today, 5 years from now, what is it that you think one thing in the IBC that should probably just go because it's outlived its utility, it has served its purpose, or it's just not relevant? And what do you think is something that which must come in? Anybody, Mr. Ravi, if you want to start, then it would be great.
Sure. So it's a thoughtful question. 5 years is a long time in India, considering so many changes take place. But I would think that what must come in is a pre-pack that works, right? So we have 250 billion of NPLs in India. Even if they get resolved at the current 30 cents, you're talking about humongous amounts of money that has to come from foreign capital, because the savings in India or the strategics do not have access to that kind of money. So for that, you need to bring in efficiency, because all of these NPLs are kind of like in an oil pipeline. They have to come out of the other end. How they come out, how much value, what the velocity is, will depend on the inertia in the system. And the longer it takes, the less the value will be left in these companies. So pre-pack, as we have been reading in the newspapers in the last couple of days, is on its way. So we hope that it is going to be like the vaccine for IBC, and see where it goes. And as far as what must go, I think I would like to say that I'm extremely impressed with the intent of the government to keep the IBC process by IBBI moving along, and to take whatever jurisprudence is getting created, and if it is not with the intent of the framers of the law, to bring it back, to tweak the law to make sure that it moves forward with current timelines. And I hope that continues to take place, and the law should be dynamic and it should not be static.
Thank you so much. Mr. Badrinath, your views?
I think speaking from an entrepreneur's perspective, I need a quicker money. The whole resolution process should aim to bring in a quicker money to ensure that the institution is back in its tracks, and it has to come back to its kind of a full steam and should deliver the value for money. I think that's what the objective I'm looking at it. The kind of the processes that are currently on, they should be cut short. They're possible to be cut short by setting up the institutions, by bringing in the professionals, by bringing a commercial acumen to the whole process as such. I think that's what I'm looking at in a period of 5 years from now. Maybe it should collapse to a time of as much as just 90 days. Within 90 days, this is something which is doable. That's one thing which I'm targeting. The money should come faster. Institution should come back to its normal working. That's the first thing. What should go out is the kind of the subjectivity, the kind of a bad blood towards a kind of a failed enterprise, and the kind of an outlook and the strangulation, financial strangulation that is happening at this point of time by the COC, you call it, by the kind, whomsoever you call it. There is a lot of strangulation that is happening in the system. That strangulation should ease out, and it should facilitate for a faster movement. These are the twin objectives which I'm looking at.
I would only say one sentence and say that we need to change the law with changing times. And I think Ravi made a point of pre-pack. It is already knocking at our doors. We are looking at cross-border within the next 5 years. And to my mind, another Supreme Court took an initiative. It constituted an expert committee to make a recommendation to the government to make a mediation law. The act has already gone to the government, and I was told this afternoon that's under consideration. And if that act comes, which mandates a resolution process before even going to 7 or 9 or 10, then I think that itself would be a step forward where a corporate debtor may get an opportunity to resolve through the process of mediation a matter which otherwise would be a restructuring with somebody else coming in. And we should now also make our professionals a little more with respect to information memorandum. I think the resolution applicants are not getting the requisite information, and that information needs to be put in place. Once we do that, I'm sure Ravi will put in tons of money, dollars and pounds in this economic situation, and will work out wonders.
Thank you, Mr. Chandiok. Mr. Thakkar, any final views from you?
No, I wanted to endorse and supplement the view of Majid Singh and Badri, that as an entrepreneur, we need a quicker money, and that's an ideal situation. But what need to do for the quicker money? And the answer is that, as Mr. Amarjit was trying to mention, that we do not require the one commission after other commissions. I absolutely agree with him. The point which I was trying to tell is that you need to reduce the burden on existing judiciary tribunals. So either you have a specialized tribunal, super specialized tribunal by way of financial exclusive tribunal, or you come out with the exclusive IBC tribunal to expedite the process and recover or maximize your existing wealth, so that more and more commercial interest from the overseas transactions will be invested, will come into India, and they can exit also. And having said that, improving in the quality of the resolution professions, be it individual or institutionalized. And then I said that chartered accountants and company secretaries and advocates, myself is a company secretary and advocates. And I never mean to say that advocates and company secretaries cannot become the entrepreneur. It is difficult for the entrepreneur to become the advocate, but advocate can easily become the entrepreneurs. So with this competency, we can achieve desired speed and efficiency in the system. And IBC is a good, excellent legislation to achieve the desired things.
Thank you. Thank you, everyone. I think one thing that has certainly come out from our discussions is that while everybody understands that this is a legislation which is here to stay, it has been implemented well. I think the biggest strength about the legislation has been the fact that it has undergone so many changes, which primarily means that it is listening to the industry, it is listening to the stakeholders and plugging the loopholes or plugging the issues that may come across. But it's never done till it is done. And I don't think in law there can ever be a state where anybody can say that this is what it is and I'm absolutely happy with it. There are constitutional challenges which happen to the constitution itself even today. So I don't think we will ever reach a stage of perfection. And as one of you mentioned, that we are not God, but I think it is certainly a legislation, and it's not just the regulator or the judiciary or the government or even the other regulators who are looking at it from a supporting perspective, but it is practitioners like us, not just legal practitioners, but people in the industry, people like investors who are making the right noises and who are making their voice heard, and that is certainly helping. So thank you so much, everyone, and have a good afternoon. Thank you.
Thank you, esteemed speakers, for sharing your inputs. Ladies and gentlemen, we hope that you all are enjoying the great content shared by experts. Keep tweeting event highlights on social media using the hashtag #ETLegalworld. Stay connected for the next session.